I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Good morning, you're Norberto Armenta, and this is cause number 25 DCCR 0168. Mr. Armenta was previously in court, entered a plea of guilty to driving while intoxicated, third or more, in addition to pleading true to prior offenses, making this a second-degree felony offense for punishment purposes. And there was an agreement of a cap of 12 years and to dismiss the evading as part of that plea agreement. I've received the pre-sentence report as well as a whole packet that the defense provided that has certificates and different things that I have reviewed. Has everyone had an opportunity to review the pre-sentence report as well as those other documents?
Yes, Your Honor.
I have.
Are there any additions or corrections?
No, ma'am. No, ma'am. No, Your Honor.
All right, Mr. Kimler, you may proceed.
Well, Your Honor, we start as usual with the criminal history, which is rather extensive, Mr. Armenta. I will say I've spoken to him at the jail extensively and reviewed the case. And this is really an unusual fact situation in that he's the one that called 911 on himself in the vehicle because he was having what I thought, and I'll let him explain it to you what the reasons that he did call and concerns. And as a result of that, received the DWI. The evading detention, Mr. Armenta, is from Harris County and has had some bad experiences with law enforcement. I think there was a low speed failure to stop. They did deploy the spike strip and he ultimately came to a stop. But he related to me that he was in fear, I guess, of law enforcement and wanted to get to a spot where he would feel safe pulling over, and that's what he did. But I'll let him elaborate as to his thinking on that.
Well, but what you're thinking is on that really isn't going to matter. You were on cocaine and Xanax at a minimum that day, so your thinking was not clear because you were under the influence of a lot of things in driving.
That's
okay.
correct, Your Honor. And I think that he relapsed, I would say, because he has indicated, and I guess enough factually demonstrated that he is trying to maintain a sobriety through our religious faith-based rehab, or I'll say programming, but efforts to maintain the sobriety. And the certificates that have been provided to the court were obtained by him while he was in custody in Harris County Jail, awaiting transfer over here. He does have a motion to revoke probation in Harris County for a DWI that will be resolved after this case is disposed of. In the VSI, again, relating to criminal history, there's some self-reporting that Mr. Armenta did as far as gang affiliations. I want the court to know too that these are self-reported by Mr. Armenta. He didn't have to inform the probation officer. These are things that he told the probation officer in good faith about his history because he wanted to be honest about things. It certainly doesn't make him look good or any better, but it was important to him that he be honest about that. We're not asking for probation on this. It's a 12-year cap, and I think Mr. Armenta really is in a better position than I am to give the court an indication of where he is in his life as far as his recovery, what his plans are, what his efforts have been. So I would defer to him at this point to talk to the judge and let her know where you are.
Did she get my college papers?
Yes, and he also, yes, there's some paperwork. He was in San Jacinto College, I think.
Right.
Yes, ma'am. Good morning. My whole life, I've been a criminal all my whole life. 2015, I began to change my life. I gave myself to God, and there's not much I can say, but I never, ever since I started doing recovery and trying to change my life, I had difficulties, and I was doing good, and I relapsed. And Your Honor, I never dialed 911, and what they're teaching us is to take responsibility for your actions, and and that's one thing that I wanted to do is I wanted help, and I wanted to get locked up for a while and take classes, and that's what I've done before, and that's the only way I knew how to get help. And I apologize to the courtroom for my mistakes that I've made, but I've never called 911 on myself, and I feel like that's a big step as well. As doesn't make it any better, I wasn't asking for probation, 2 years, 3 years, 4 years. I asked for 5 because I felt like, I don't know if that was a good punishment for me, but I felt like I needed to get away for a while from the wrongs that I did, my mistakes, and I'll take full responsibility for my actions. And I'm sorry for what I caused. But I do have a daughter, and she's asking for me, and I'm just trying to better myself for her. And I never thought that changing my life would have to deal with me being an addict, and that's what I'm dealing with now.
Thank you.
Sorry.
Thank you. Ms. Malfino?
Judge, obviously, his criminal history dictates that somewhere in the range of 10 to 12 years would be appropriate for him and would have been a sentence that was mitigated by the cap. I do appreciate his honesty. It's not what we typically hear from a defendant. Usually it's the excuses. I appreciate that he's not even asking for probation and insulting the court that way, so I'm deferring to what he thinks is best.
So, Mr. Armenta, I make notes and go through the pre-sentence reports. Obviously, before court, I use a highlighter to highlight convictions and things, and usually the prettier it looks, the worse it is. With highlighting, yours does not look good. Your criminal history, like you said, is ridiculous. I appreciate what you're trying to do now. Obviously, it's a little late or a lot late, but it's Ms. Malfino's right. People don't take responsibility. I had a note on here for pretty much what she said, that 10 to 12 was probably the right thing to do. I think I'm inclined to give something for what you are trying to do, but 5 years is not going to be it. So I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. And at this time, find you guilty of driving while intoxicated, third or more. Find those prior offense true. Sentence you to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Kimler. Good luck to you, sir. Hopefully you'll continue doing what you have been. Ms. Holmes, on Claudia.
This wasn't a punishment for relapse alone. It was a sentence for repetition, for every time the system warned him before. Calling 911 was a step forward. But when lives are at risk, even progress doesn't cancel consequences. Should honesty and self-reporting reduce prison time? Or does public safety always come first? Drop your thoughts below.